Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in dockets number 2021-89E and 2021-90E. We're going to take roll, and present in the hearing room, we have Commissioners Belzer, Powers, Thomas, C. Williams, and J. Williams. Joining us virtually, we have Commissioners Irvin and Caston. General Counsel Wessinger Hill, could you please read the docket?
Yes, sir. Thank you, Mr. Chairman and Commissioners. The proceeding before the Public Service Commission today is in dockets number 2021-89E and 2021-90E. This is the 2021 avoided cost proceedings pursuant to South Carolina Code Section 58-41-20 for Duke Energy Carolinas LLC and Duke Energy Progress LLC. On March 10th, 2021, the Commission first scheduled this proceeding to begin today at 10 a.m. Additional notices for this virtual hearing were also provided by the Clerk's Office on May 4th, 2021. The parties and witnesses are present virtually, Mr. Chairman and Commissioners, but the first matter of business, there is a preliminary matter that must be addressed. There was a motion filed on Friday, July the 30th, 2021 by the Office of Regulatory Staff for leave to present its witnesses at the hearing scheduled for September 16th and 17th of 2021 related to the third-party independent expert/consultant.
Thank you, General Counsel Wessinger Hill. So let's take appearances to see who we have here with us. Then we're going to hear oral arguments from the Office of Regulatory Staff and any parties that wish to make arguments regarding ORS's motion. Who do we have appearing for Duke Energy Carolinas LLC and Duke Energy Progress LLC?
Good morning, Mr. Chairman. This is Frank Ellerby of the Robinson Gray Law Firm, appearing for the Duke companies, and with me is Brett Breitschwart of McGuire Woods, who has been admitted pro hoc vici, and we will be representing the company in this proceeding. Thank you.
Good morning, gentlemen. Thank you for joining us. Johnson Development Associates Incorporated.
Yes, sir, Mr. Chairman. Weston Adams, Nelson Mullins. I'm here with my partner, Court Walsh. With the chairman's permission, I'll be here till about 11:30, and then Court will carry the baton from there.
Your request is granted. Attorney Adams, thank you for joining us today, gentlemen. Carolinas Clean Energy Business Association.
Mr. Chairman and members of the commission, I'm Richard Witt from the Witt Law Firm. I'm here for Carolinas Clean Energy Business Association.
Good morning, Attorney Witt. Thank you for joining us this morning.
Good morning.
South Carolina Department of Consumer Affairs.
Good morning, Mr. Chairman, Commissioners. Roger Hall with the Department of Consumer Affairs.
Good morning, Attorney Hall. Thank you for joining us this morning. South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Good morning, Mr. Chairman. This is Kate Mixon on behalf of the South Carolina Coastal Conservation League and Southern Alliance for Clean Energy. And I also have Attorney Emma Clancy here with me today.
Good morning, ladies. Thank you for joining us this morning. Office of Regulatory Staff.
Good morning, Mr. Chairman. This is Ben Muschin with the Office of Regulatory Staff. Also in the room with me is Mr. Andrew Bateman.
All right. Good morning, sir. Thank you for joining us this morning. All right. So the parties have made their appearances. As General Counsel Wessinger Hill has already announced, we have a preliminary matter, and that matter is the Office of Regulatory Staff's motion requesting leave that their witnesses present last. Attorney Muschin.
Excuse me. Thank you, Mr. Chairman, members of the commission. Again, for the court reporter, my name is Ben Muschin. I'm appearing today on behalf of the Office of Regulatory Staff. At the outset, let me say that ORS, we appreciate the hard work that the commission has put in on this and the other avoided cost proceedings over the last few years. And as the commission is well aware, these proceedings have presented a number of challenges, and the commission's had to make a number of difficult decisions in determining the appropriate avoided cost rates to be paid to QFs and in particular solar generating facilities. In this proceeding, I believe that all the parties who are remaining to this docket would agree that we are pleased that we've been able to come to a stipulation in the DEC and DEP avoided cost proceedings and to present that filed stipulation for the commission to consider in this matter. But with that said, ORS certainly understands that the commission has a duty and an obligation to evaluate the proposed avoided cost rates, the positions of the other parties, and ultimately the stipulation that has been filed so that the commission can approve avoided cost rates that are just and reasonable to the ratepayers of the electric utility and that satisfies the requirements of Section 85841-20. And as part of that, ORS understands that the commission has an interest in hiring a consultant pursuant to 584120 subsection I to assist it in evaluating those avoided cost rates and the related issues. The concern that ORS has, though, is that the schedule that was established by the commission, I believe on Thursday, requires ORS to present its witnesses in this case before the expert report and before any expert recommendations are made available to the parties. As we understand it, the current schedule would require the parties to proceed with the merits hearing this morning and to present our witnesses and the stipulation. The consultant would then review the testimony and the stipulation, could conduct discovery, and then would file its report on August 23rd. The consultant would then appear at a hearing on September 16th and 17th, and the commission has indicated that the parties at that time can cross-examine the consultant and the commissions would ask questions of the consultant. The concern, though, is that this schedule puts ORS at a procedural disadvantage that we do not believe can be overcome the way the schedule is currently structured. So, for example, Mr. Chairman and members of the commission, the stipulation provides in paragraph C6 that if after execution, but prior to a commission decision on the merits in this proceeding, if a party is made aware of information that conflicts with the information upon which the agreement is based, then that party may withdraw from the agreement. So under the current schedule as contemplated, Duke and ORS are going to be required to present their witnesses today, enter the pre-filed testimony, the exhibits, and the stipulation into the record of this proceeding. And presumably the commissioners will ask questions of the witnesses as to whether the stipulation is appropriate and results in rates that are just and reasonable. So based on what we know right now, of course, ORS would support that stipulation and essentially would be on the record locking ourselves into that agreement. And while we believe that the consultant ultimately will agree with the positions of the parties and support the stipulation, it is possible that the consultant may find some issue or develop some fact or have some concern that ORS and the other parties have not yet thought of, and the consultant may make some alternative conclusion. The problem is, if that were to happen, ORS would have already been locked into the stipulation and wouldn't have the ability to present additional or rebuttal testimony, either agreeing with the consultant or explaining why the consultant may have erred in reaching their conclusions. Our only recourse, based on the schedule that's been approved, would be to cross-examine the consultant, but we would not have the opportunity to introduce direct evidence or testimony of our witnesses to address any of those conclusions, which we believe presents some due process concerns. But we believe that the process that we have outlined in our motion is a logical and reasonable way to alleviate those procedural concerns. Essentially, what we're requesting is being able to withhold putting up our witnesses today until after the report is issued and after the consultant has made its presentation during the September 16th hearing. That procedure would give us the ability to review the consultant's conclusions, listen to the consultant's testimony, and then, if we think that it's necessary, offer supplemental testimony on those matters. The consultant would still be able to review the pre-filed testimony in this proceeding. As part of the commission's order on Thursday, I believe the commission said that directed the consultant to look at the filings on DMS, so they would still have that opportunity. The consultant could ask questions of ORS and the other parties through discovery, which was what was contemplated by the commission on Thursday. And the commission could ask questions of ORS at the September 16th through 17th hearing, both with respect to the stipulation and any comments that we may have on the consultant's recommendations. Finally, we suggest that this process would comport with Regulation 103-842.B, which contemplates ORS putting its case in chief last. So ORS doesn't believe that there would be any disadvantage to the consultant, the commission, or the other parties of record by allowing ORS to present its witnesses at the September 16th to 17th hearing. And we believe that the process that we have requested would ultimately promote administrative economy, because it would allow our witnesses not to have to appear at two separate proceedings. Thus, we would avoid additional costs that ultimately would be borne by Duke's ratepayers. So in conclusion, we would respectfully request that we be allowed to delay presenting our witnesses today and allow them to appear at the September 16th to 17th hearing after any presentation of the London Economics Report. Thank you, Mr. Chairman.
Thank you, sir. Do any of the other parties wish to respond to Attorney Mustian?
Mr. Chairman, Roger Hall, with Department of Consumer Affairs.
Yes, sir.
Yes, sir.
Just a brief comment, and we certainly do not object to ORS presenting their testimony at a later date. And I guess for the record as well, we did not join the stipulation, though we did formally state that we did not oppose it. The only comment I would make is, to me, it seems that the hearing in September may not be necessary. The Commission's order in this matter, 2021-520, stated that the consultant may be required to attend a hearing. It seems to me, given the stipulation that if the consultant finds it reasonable, has no suggested changes, then a hearing in September would not be necessary. At that point, so therefore, if ORS is willing to forgo that, I guess our suggestion would just be that we don't have a hearing in September simply for ORS to present testimony. If it's not required, if the consultant agrees with the stipulations, then again, we don't see why it would be required. And additionally, I believe there's another motion pending from one of the commissioners about reconsidering hiring the consultant potentially as well. So again, we don't object. I just wanted to raise that issue that it seems to me that a hearing may not be guaranteed to happen in September. So thank you.
Thank you, Attorney Hall. Anyone else?
Mr. Chairman, Frank Ellerby for DEC and DEP briefly, sir.
Attorney Ellerby.
Under the very unusual circumstances that are presented today, the Duke companies do not oppose the ORS motion. Hope that this won't come up again. We don't think that our position has any precedential effect in the future. We are willing and think it would be helpful, hope and expect that it will be helpful for our witnesses to testify this morning and explain the stipulated agreement among the parties and answer questions. We hope that it will be helpful not only to the commission, but to the third-party expert. We believe that whether the Duke companies will need to respond to the report by the third-party consultant, third-party expert, will depend on what the third-party expert decides and what they conclude. We may ask the commission for an opportunity to respond to that. It will depend entirely on the conclusions reached by the third-party expert. That's not something the commission needs to deal with today, but just wanted to flag that that's a possibility that we would, depending on that eventual determination, be asking the commission for permission to respond. Thank you, sir.
All right. Is there anyone else? Commissioners, questions for the Office of Regulatory Staff?
Mr. Chairman.
Commissioner Irvin.
Thank you. I have a couple of questions, Mr. Mustian, if you would allow me a chance to make an inquiry. isn't it wise to go ahead and put your pre-filed testimony in the record today so that it will be a part of the record for the independent expert to consider?
Commissioner Irvin, we certainly would be willing to do that. As part of the stipulation, the parties have stipulated to the direct testimony of our witnesses, Ms. Gretchen Poole and Mr. Brian Oree. So we certainly would have no objection to entering that pre-filed direct testimony into the record in this proceeding. What we would request is that as far as any questioning on that testimony, that come during the September 16th to 17th hearing so that we can address those issues as well as any issues the consultant may present at the same time.
Thank you. Would you be willing to move the pre-filed testimony into the record now so that we'll have it in the record? I understand you don't want to call the witnesses to answer questions today, but would you at least make them a part of the record?
Would certainly be glad to do that. Obviously, that would be subject to any objections other parties may have, which I would presume there would be none, but we would be happy to do that.
Thank you. And my next concern is that could we find ourselves in a situation down the road, depending on what the expert report says or recommends or concludes, do we run the risk of some party or parties withdrawing from the stipulated settlement agreement?
There certainly is that risk. I hate to speculate as to what may occur. However, as I did mention, the stipulation does say under, I believe it's paragraph C6, that if some new information does come to light, then that party does have the opportunity to withdraw, and that presents a potential problem of if the stipulation has been entered into the record and if ORS has been required to provide testimony supporting that, it locks us in such that if some new issue were developed by the consultant, then we would not have an opportunity to review that and potentially see if that affects the stipulation. And so under this procedure, we believe that this would allow us to review it. We could supplement our testimony at the September 16th to 17th proceeding if we needed to, and we could address it in that manner.
Well, that brings me to my next point, and that is, of course, Office of Regulatory Staff is charged by law and under statute to represent the public interest, true?
Yes, sir.
And of course, Mr. Hall is representing Consumer Affairs, and they of course provide further protection for ratepayers and consumers as it relates to the issues before us. Is that correct?
Yes, sir.
And so I'm wondering, given that we have a stipulated settlement by the parties, which is my understanding, no one objects to the settlement. Is that true?
Yes, I believe that's correct, Commissioner Irvin.
Right. Do you think a wiser course might be to reconsider our decision to use an expert in these dockets, given the fact that we may find ourselves at the end of the proceedings having to hold a full-blown evidentiary hearing?
Commissioner Irvin, I would not presume to take a position as to how the commission should act on a situation like that. The statute obviously allows the commission to engage an expert in these proceedings. We understand if the commission feels it necessary to do that. We believe that we have presented a stipulation that is fair and reasonable, results in just and reasonable avoided cost rates, and that when the commission looks at that they will hopefully agree with the position the parties have taken. However, we certainly do understand the commission's desire to fully look at these, to take an independent look and to make its own determination. So, I certainly would, we certainly would follow and abide by however the commission decides to move forward with hiring an expert in this matter.
But as it's been previously noted, it may turn out that no party has an objection to the experts, third-party independent experts report or recommendations. And in that event, your concerns would be mooted and, you wouldn't have to even go there, right? And call your witnesses last.
Absolutely. If the expert agreed with the stipulations, or if there was some new issue that all the parties were to agree with, then that would not be necessary. But unfortunately, in the position with the schedule the way that it is now, we don't know what the commission, what the consultant may conclude and may recommend. And so that's why we believe, since the commission has already scheduled this hearing for September 16th, that allowing us to put our witnesses up last would obviate these concerns in a, what we believe is a very logical and reasonable manner.
But in my hypothetical scenario, you've protected yourself for the record by making this motion and having it heard today. Why not just wait until we know what the expert says, and then if you have concerns, you could proffer your testimony at that time if you have concerns about the report.
And Commissioner Irvin, just to make sure I understand, under the procedure that you're suggesting, we would go forward with our witnesses today and then present our witnesses again at the September 16th hearing if we needed to. Is that?
That's correct.
Okay.
That's correct.
We certainly would have no problem doing that either. We believe that would create some administrative economy issues of requiring our witnesses to reappear at 2 different times, which would increase costs and expenses. However, we certainly would be willing to do that and agree to that if the commission were willing to move forward in that manner.
Thank you, sir. Those are all the questions I have.
Commissioner, questions for Vice Chair Belzer? No? Commissioner, questions for Attorney Muschin? All right, if there are no further questions for Attorney Muschin, we're in recess for 15 minutes. Good morning, ladies and gentlemen. We're back in dockets number 2021-89E and 2021-90E, Duke Energy Progress, LLC, and Duke Energy Carolinas, LLC, 2021 avoided cost proceedings. Let's take roll. Present virtually, we have Commissioners Caston and Urban. Present in the hearing room, we have Commissioners C. Williams, Thomas, Powers, Belzer, and J. Williams. Ladies and gentlemen, we will recess this hearing as we're going to reconvene the commission business meeting, special business meeting at 10:45. We will reconvene this hearing at 11:15 or immediately after the conclusion of the special business meeting. We're in recess.